applications and an appeal in the matter of Majera and the Home Department.
Yes, Miss Weston.
My lady, I represent the appellant this morning, assisted by Ms. Dirier, and I'm opposed by Mr. Tabori for the Secretary of State.
Yes.
Could I just check that the court has what we think it should have? That the correct bundles and the skeleton arguments and what have you?
Well, the what I have as the core bundle is the original core bundle created by the office, which runs to 111 pages. When my clerk inquired last week, was there an up-to-date core bundle? We were told there wasn't. It may not matter, but that's what I have. I'm not sure that we all have the same thing. Added to it, of course, are the main skeleton arguments. And then hidden away in the supplementary bundle, which I think hasn't changed, are some of the application, cross-application skeleton arguments dealing with the without prejudice point.
Indeed.
So I hope we've got everything.
Yes. Yes.
Tell me if we haven't.
No, as I understand it, I think there was some confusion about documents that ended up in the supplementary bundle that should have gone into the core bundle. As it was, we kept the core bundle as it is. My lord is right, it should have 111, 112 pages, depending on how you count them. And then the the supplementary bundle, and then the replacement skeleton argument with my note. I don't know if the court's seen it. And then there's an additional skeleton argument from the Secretary of State. For the avoidance of doubt, there's no opposition to the Secretary of State putting in that skeleton argument.
That's a very short one, isn't it?
Yes.
Yeah, that's fine. Certainly, I've got that. I've got your replacement skeleton argument.
I don't see that the additional one.
The note. There was a note appended to the replacement skeleton argument. Oh, my lord, are you referring to the Secretary of State's additional skeleton argument?
That looks like that.
Oh, yes. Yeah, thank you. Yes, I have got that.
Yes.
I'm sure I've got the note.
If I wasn't far
actually.
away.
Now, yes, like my lady, I'm not sure that.
Is that the appellant's note? Oh, looking at the essential reading list. Is
Yes.
that the appellant's note on proposed order of submissions?
Quite so. That's
Oh
it.
right. Well, we don't have that. Tell us what it would have said if we'd had.
What it proposes, given the way that the grounds are structured, it's right, we say, that if the court's with us on ground one, so that's the ground number 1, relating to whether there was a material error of the law which justified the Upper Tribunal in setting aside the First Tier Tribunal's original decision, then the court doesn't need to go any further.
No.
Similarly, in respect of ground 1, little Roman numeral 2 and 3, again, if the court's with us in respect of, it isn't with us in respect of ground 1, but is in respect of ground 1, 2 and 3, then again, the court doesn't need to go on to deal with ground 2. Because the solution in that case, if that ground is correct, remittal to the First Tier Tribunal. So looking at it, wanting to make the best use of court time, what I'd actually said in the note, and I am disappointed that it hasn't made it to the bench. What I'd said was that the appellant proposes that the court hears first from the parties on ground 1, 1 and 2, and thereafter determines whether, in its view, it's necessary for the court to proceed to hear submissions on the matters in respect of ground 1, 3 or 2. And I recall, and my Lord Justice Bean may not do so, but I recall that the court took a similar approach in the W case, which was about where my Lord sat with Mr. Justice Chamberlain on a divisional court judicial review, and that was an approach. The court dealt with one ground which would have disposed of everything first, just made a decision about what it thought of that ground, and in the end that was dispositive of the case. So
have you discussed this with Mr. Tabori?
I haven't gone so far as to discuss it with him, but I did send him a copy of the note and flag it up to him, and he may have submissions opposing that. But it seemed to me that the best use of court time may be that if the court, it may be that the court can't reach a view on ground 1.1, but if the court can, it does seem to me that it would be an appropriate use of court time to determine the matter on that basis without having to go to the rest of the case.
What we had thought was that we would simply hear you on all grounds, Mr. Tabori on all grounds, you in reply, and that I don't know whether anyone was suggesting it, but we didn't want to take the without prejudice application and cross application as a preliminary point, simply that you, when it came to, I think it's ground 1.3, is it, or the one where you say, if we fail on our primary argument that the Upper Tribunal had no business to interfere at all,
Yes.
then our fallback is that we should have had a new trial in the First Tier Tribunal.
Yes.
As to that, you say the Home Office letter of whatever date it is a point in your favour, and Mr. Tabori says no, it isn't. It's not of any real value at all. We'd rather deal with it at that point rather than have learned arguments about whether it's admissible or not. We've seen it.
Yes.
And we would get up. So that's how we propose to deal with that.
Yes.
We wouldn't normally take the grounds one by one unless it was by consent.
Yes, I accept that. If Mr. Tabori is opposed to that way forward, and the court will hear from him. I did try and flag it up as an earlier point,
yes,
so that the court would have a chance to think about it.
It is one way of doing it,
yes,
and in some cases it works very well. But let's do the more conventional approach. I mean, obviously, ground 1.1 is the heart of the case.
My lord.
And you'll no doubt spend a significant proportion of your time on that. But otherwise, I think we'll stick to the usual.
Indeed, and it may be good news to the court that on reflection, we have decided that the Secretary of State should be permitted to argue the ground in respect of remittal.
Yes.
Good. We don't pursue
well, that was our view too.
Yes.
So,
now we're here.
yes, quite.
But I would point out that it will be Ms. Derier who will be making the submissions on ground 1.3, that remittal ground.
Very glad to hear it.
I'm mindful of the practice direction.
Yes.
So if the court has everything, then I propose to begin with a short introduction to the facts. If I might take as read what's in the skeleton argument.
Yes, please.
This case concerns Mr. Majera, and he arrived with his mother and siblings from Rwanda. Now, I understand at various points, a point has been taken about whether Mr. Majera comes from Rwanda, but I don't understand that to be a point which is still live, certainly not in these proceedings. And the court may, if it's had a look at the witness statement, have noted that both his mother and siblings have previously been granted Rwandan passports.
Wasn't there a problem because passports were applied for but no photographs were attached, so no one was terribly surprised when they weren't granted?
Well, I think in respect of the family, there's no dispute about whether they're entitled to those passports. In respect of Mr. Majera, a different approach appears to have been taken by the Rwandan authorities. We don't know why, and Mr. Majera speculates about why that might be. But certainly for today's purposes, there's no dispute that Mr. Majera comes from Rwanda and that he came in the circumstance in which he's described. It's fair to say that Mr. Majera's case, and it doesn't appear to have been disputed, that he had witnessed extreme violence during the Rwandan genocide, including the murder of his father, and it's certainly the sort of experience that no child should have to go through. And it's to Rwanda that the Secretary of State proposes to deport the appellant. In summary, following his arrival in the UK aged 14 in '97, his mother's mental health deteriorated and the children were made subject to child protection measures. My lords, my lady, one of the documents from the care files and the child protection minutes of the child protection meeting are in the supplementary bundle. I wasn't planning to turn them up. Turn this up here, but it's in the supplementary bundle at 299. I wasn't planning to go into. It goes into some detail about the position of the children and necessary interventions by the local authority, which was Bromley. Mr. Majera, of course, was 18 by the time that intervention, and certainly that child protection meeting was held, and wasn't included in respect of any child protection matters for that reason. My lords, my lady, there is a significant offending history in Mr. Majera's case. It's summarised at pages 38 and 39 of the supplementary bundle. I'm wondering whether it's helpful to turn up the chronology, which is found there.
Which bundle?
It's in the supplementary bundle on pages 38 to 39. The offending history is in a number of places, including in the decision letter, which triggered this appeal, but for convenience it's set out in the chronology.
Can you just give me the bundle number?
38 and 39, my lord.
Yes, and none of this is in dispute.
No. So we see from that chronology that there was an initial number of driving offences, and it's fair to say that the nature of that offending escalated in seriousness. And then in 2006, Mr. Majera was convicted of 10 counts of robbery, which were committed as part of a group on dates between the 24th and the 15th of October and the 15th of November 2005. So it was during that period that the robberies were committed.
You pleaded guilty, did
Yes.
Yes.
I mean,
He did not straight away, but enough to get him some reduction on the
20%
sentence. Yeah.
reduction, yes. So,
I wasn't going to make specific reference to the sentencing marks. They are in the bundle. I don't know if the court wants me to just.
I have read them, though I can't remember where.
They're in
where
the first tier tribunal decision,
Yeah.
and then the second one as well, I think.
Yes.
But the whole of they are. That's
They're all
right.
set out in full there.
Yes, they are at 311 of the supplementary bundle. The whole of the remarks are there.
Can I just ask one question about
Yes.
My arithmetic is notoriously bad, so you'll give me. He was born on the 10th of January 1982.
Yes.
He arrives here in April 1997, and you said, and I think the Supreme Court
Yes,
also said he
14.
was 14.
Yes,
Um,
I think it's
my arithmetic makes that 50.
yes, it does. It does. I think that certainly that would be correct. I know that there have been 2 dates of birth given by his mother on various occasions. I think both 83 and 82 were given.
What is the 1st of January?
So forgive me, I should have been on top of that.
It's just, well, I think you're in good company. So I think the Supreme Court said the same.
But on any account, that was serious offending. I can't say otherwise. The Secretary of State made a deportation order on the 13th of November 2012. While he was still in custody. He then had an appeal against deportation, and the First Tier Tribunal's rejection of that appeal is at Supplementary Bundle 134. For reasons that I'll come to, the First Tier Tribunal's judgment that I'm asking the court to restore today was required to treat that judgment as the starting point.
Yes.
And that's the Deportation principle in shorthand. For completeness, an appeal from that decision to the Upper Tribunal was rejected in 2014. We don't have that judgment, but it's not material for what the court has to decide today.
Was it substantive or just a refusal?
I think it was a rejection of permission, but I'm unable to say with certainty. So
Anyway, he becomes appeal rights exhausted in what,
2014.
2014.
He's still in custody at that point, and then 2 other notable dates. The first is in July 2013, when the parole board recommends transfer to open conditions. And the second is that the parole board directed release on licence in 2015.
So done 9 years by then.
Yes. So ordinarily he would have been released to approved premises, but he was redetained under the Immigration Acts and held under immigration powers. On the 2nd of April 2015, he applied to revoke his deportation order, and on the 30th of July 2015, Mr. Majera was granted bail and released into the community, and it was that decision which underpinned the Supreme Court case. There was an initial refusal to revoke the deportation order, but the Secretary of State withdrew that decision in 2015.
Do we know why?
It was challenged, I think, with a PAP. I think it was.
Has a pap feel about it, really, doesn't it?
Yes, it certainly does. It was challenged with a PAP, is my recollection. And it must have been that the author recognised that there were some aspects of it which were defective. Then there's quite a long gap before the Secretary of State makes a decision on the application to revoke a deportation order. It might be helpful for the court to know at this stage that the test for applying to revoke a deportation order where there's a sentence of over 4 years is the same very compelling circumstances test as one sees. So the fact that that's the nature of the application doesn't make any difference to what the court is looking at and deciding, in effect.
Where's that test? Where do we find that test? Is it in the rules?
It's in section 117C6 of the Nationality and
Well,
Immigration
that's
Asylum.
I know, but you said the
Authority.
test is the same. Is that just a submission of law, or is it just something that's in the rules that it doesn't make a difference?
Yes, it's in the rules. It's Rule 13, I think.
Yeah.
It's in the bundle of the authorities. I can come to it when I get to do some more law, but I just wanted to give a heads up that we're not unduly concerned with the different types of applications being made. In essence, the only kind of a right of appeal that you have is an appeal against a refusal of a human rights claim. And the terms which were applied are very compelling circumstances throughout the rules, remarkable and indeed pleasing degree of consistency between those rules and the statute.
So on what ground was the application to revoke the deportation order made in 2015? I understand that the grounds on which the case is being argued now.
Yes.
But in 2015, what was the basis of seeking to revoke the deportation?
It was Article 8. It was that the fact that it was that there are very compelling circumstances. In fact, I think in 2015 there wasn't that consistency between the revocation test and the various other. That's actually changed in the interim between when the application was made. So I think it was actually a slightly lower test. Might have been more like material change of circumstances for the revocation test under the rules at that time. I know that they changed in the interim. But by 2015, there would have had to have been a human rights claim. Otherwise, there would be no right of appeal. So so the decision would have to have been harnessed to a fundamental right protected by Section 6 of the Human Rights Act. Otherwise,
Understand.
There wouldn't have been a basis for any appeal.
I've just found in the 2021 decision letter, page 85, that
Yes.
answers my question about the appeals against the original decision. As you say,
Yes.
it's turned down by the First Tier Tribunal. Eventually, at the second time of asking, gets permission to appeal to the Upper Tribunal. Upper Tribunal dismisses the appeal. Application comes to this court refused, so he becomes appeal rights exhausted. November 2014, but then he applies to revoke the deportation order only 5 months later. So I was wondering what had changed between November 2014 and April 2015, or what was said to have changed.
Yes, I'm afraid I'm unable to assist with the detail of that application. It's not in the bundle. I should say that although I can understand why the courts are asking that question, by the time we get to the date of decision under challenge, that decision would have to be made on the basis of the information before the decision maker at that time.
Oh, sure, and I understand. I mean, compressing it very much, one of your main points is for 6 years he's kept out of trouble. But that wasn't available in 2015, so
Agreed.
Anyway, we haven't got it.
So in essence, nothing material apart from the passage of time and what, and I'll come to what Miss Lackenby says about it, the tribunal says about it, but nothing happened at the Home Office end between 2015, when the decision to refuse to revoke was withdrawn, and the 2021 decision. However, I do understand that shortly before the decision maker came to determine that application, that there was correspondence from the Home Office saying, is there anything you need to tell us about what's happened in the intervening period, and that information was provided. So by the time the 2021 decision was made, it had information and evidence regarding the current case. So then the courts turned up the decision to refuse a human rights claim. So again, the decision is in that form because that's the nature of a decision which triggers a human rights appeal. There's no separate freestanding appeal against refusal to revoke a deportation order. The only kind of appeal that's available is an appeal against a refusal of a human rights claim. And that's because that's how the appellate structure is set out in the 2014 Immigration Act 2014 Act changes to the Nationality, Immigration and Asylum Act 2002. So that's a whistle stop tour up to where we get the decision.
Yeah.
So at this point, I'd like, if I may, focusing on the issues raised in round 1-1 to identify some key principles about what the task of the First Tier Tribunal was in looking at the appeal and determining it. And the first document that I'd like to turn up is in the authorities bundle at tab 6, and it's practice direction issued by the Senior Tribunal, page 29 of the authorities bundle. Now, what this practice direction does is really summarise effectively principles which are already set out in the case law. It's much more convenient to turn this practice direction up than all the various cases. Concision, obviously, highlighted at paragraph 5, but I'm wondering if the court just wants to read through paragraph 6, 5, 6, 7 and 8.
Yes, this is quite familiar territory.
Yes, I thought it might
to
be,
all of
but
us.
it's clear that prolixity is to be avoided, and the key point is that the individual should be able to tell why they've won or lost, and also that paragraph 9, that an expert tribunal, the First Tier Tribunal, will generally be taken to be aware of the authorities. The question isn't whether they've cited them, it's have they applied them. Now, the key authority here is HA Iraq. And we find HARAC at tab 16 of the authorities manual. Well, there are two particular points that I wanted to draw out of that judgment. The first relates to the proper approach to rehabilitation in the very compelling circumstances test. Can I take it that the court's familiar with section 117C odds all round? The first relates to the relevance of the proper approach to rehabilitation. And the second relates to the correct approach when applying section 117C6, which is the very compelling circumstances test. What relevance does it have that an individual doesn't fall within the exceptions in section 117C5? So those are the 2 points that I was going to try and elicit out of HARAC. So we see at paragraph 5, so this was a judgment given by Lord Hamlin with whom the rest of the court agreed. You see that at the top of 278.
Yes.
If I could ask the court to take a look at paragraph 5.
Yeah.
I don't know if the court just wants to read familiar territory.
Famous paragraph. I just note that the three appellants in HARAC the two appellants from Iraq were medium offenders. AA Nigeria was a serious offender.
Yes.
And there is reference in paragraph 5 to a medium offender.
Yes, that's a fair observation, and I accept that the AA case and its disposal are more squarely on all fours with the facts and circumstances in this case. So if I could ask the court to flip forward to the section dealing with the very compelling circumstances test. It begins at 46. But the part that I wanted to take the court to begins at 51. And that's really a summary of the sorts of factors which are material to the proportionality exercise which is conducted under section 17C6. The court's familiar with all of those. And if I could ask the court to read down to rehabilitation. So there we see that rehabilitation is a relevant factor, and we see the dispute there, disagreement between the parties as to the reason for that, and the weight that it's capable of bearing in the context of the very compelling circumstances test. Acceptance that it's a relevant factor borne out by the Strasbourg jurisprudence. There's a reference at 55 to judgment of the Upper Tribunal in RA. And then the judgment continues at D. The Secretary of State submitted that this approach was correct and should be endorsed, as while it acknowledges that rehabilitation can be relevant, in terms of weight it will generally be of little or no material assistance to someone seeking to overcome the high hurdle of the very compelling circumstance test. And then referring to the appeal, the RA appeal in the Court of Appeal, while agreeing that rehabilitation will rarely be of great weight, did not agree with the statement that rehabilitation will normally do no more than show that the individual has returned to the place where society expects him to be. They considered that it did not properly reflect the reason why rehabilitation is in principle relevant, namely that it goes to reduce one element in the weight of the public interest in deportation, which forms one side of the proportionality balance. Judgment continues, given that the weight to be given to any relevant factor in the proportionality assessment would be a matter for the fact-finding tribunal, no definitive statement could be made as to what amount of weight should or should not be given to any particular factor. It will necessarily depend on the facts and circumstances of the case. In a case where the only evidence of rehabilitation is the fact that no further offences have been committed, then in general, that is likely to be of little or no material weight in the proportionality balance. If, on the other hand, and this is the key part on which Mr. Majera places reliance, there is evidence of positive rehabilitation which reduces the risk of further offending, then that may have some weight, as it bears on one element of the public interest in deportation, namely the protection of the public from further offending. So then, quoting the Lord Justice Underhill's summary of the position in RA, what those authorities seem to me to establish is that the fact that a potential deportee has shown positive evidence of rehabilitation and thus of a reduced risk of reoffending cannot be excluded from the overall proportionality exercise. Over the page, if the court can make an assessment that the foreign criminal is unlikely to reoffend, that is a factor which can carry some weight in the balance when considering very compelling circumstances. The weight which it will vary from case to case. I would add towards the bottom of the page, paragraph.
We'll read. The paragraph does have to be read
Yes.
as a whole.
Yes, I'm happy for the court to read it as a whole.
We'll read it to ourselves. Yes.
So the point there is that the court is identifying as part of its reasoning its observation that the First Tier Tribunal judge will usually be unable to make assessments on future risk of offending because of the nature of the evidence and information that they have before them. And I'm going to be contrasting that state of affairs sharply with what the First Tier Tribunal had in front of her in this case.
What do you say about the sentence this is a citation from Lord Justice Underhill in this court, but approved by Lord Hamlin.
Yes.
The sentence beginning, the weight which it will bear will vary from case to case, but it will rarely be, etc. What do you say about that sentence?
I don't dissent from the assessment that it will rarely be of great weight. It chimes with what we understand to be the position that it will their cases will rarely meet the very compelling circumstances test.
You say this is one of those rare cases because you've got such a long period of further offending.
Well, it's not just that. There are a number of factors that the First Tier Tribunal had regard to, which I'll take the court to.
Right. And paragraph 60 of HA Iraq is obviously relevant, and you don't disagree with it. How could you?
No.
Is there anything else from HA Iraq that you'd like me to show us?
Only that it's quite useful to turn up the disposal of AA. And that begins at paragraph 101, which is page 302 of the bundle. So this was a case where it was alleged by the Secretary of State that the First Tier Tribunal, as in this case, weren't entitled to reach the decision that they did on very compelling circumstances. And we see the court gets to what the First Tier Tribunal says at page 116, sorry, paragraph 116, page 305. It actually starts with a reference to the First Tier Tribunal's factual findings, which was summarised in the AA case when it was in the Court of Appeal before it went up. And that's at 116. And that's dealing firstly with the question of undue harshness, which doesn't arise here. But if we look at 117, we can see that the court reviews the approach that the First Tier Tribunal took to very compelling circumstances. So at 78 and 79, we can see that the First Tier Tribunal took into account evidence about that appellant's childhood and early adult experiences. He indicates paragraph 79 he made the wrong choices, etc. And then at paragraph 80, very similar situation to what one finds in this case. Now in that case, obviously, there were drug factors which were material to the causes of offending, and those factors are absent here. But
Mr. AA was just in the serious offender bracket and 4.5 years for drugs offence.
yes, but yes. I'm not saying that it was exactly the same proportionality exercise. What I'm saying is that in that case, the Supreme Court looked at the way that what the First Tier Tribunal judge had considered material,
yes,
and weighed it up, and that was a conclusion that the First Tier Tribunal judge was entitled to reach, taking into account those factors, including, and it's indisputable that in that case, that the judge had placed a significant degree of weight not only on the individual's conduct in prison, but on his positive steps to reduce his risk of reoffending. That was something upon which the judge manifestly placed significant weight in that case, and the Supreme Court's view that there was nothing wrong with that. And we see that from paragraph 119. We can see that the Lord Hamden, with whom the rest of the court agreed, states that this was not a case where the only evidence of rehabilitation was the commission of no further offences. On the contrary, there was positive evidence of rehabilitation with changed circumstances and a finding that AA was unlikely to reoffend. It's also helpful in my submission to turn up the case of SC Jamaica, and we see that forgive me. Yes, at 10:15. Sorry, I'm not going the wrong direction. So this in SC Jamaica, this is a similar case dealing with section 117C. Looking at the approach to section 117C, we see that at the top of 242 that this is a judgment given by Lord Stevens, with whom the rest of the court agreed. And it's helpful to turn up the third issue in the case, which is material. The rest of the first and second issues don't arise in this case, they relate to internal relocation. But we see that at page 267, paragraph 104. So the question was, did the First Tier Tribunal judge err in her assessment of sections 117C? And
sorry, can I just get the overall picture? 2 years detention in a deportation order, FTT allows the appeal on Article 3 and 8 grounds. Upper Tribunal affirm. Court of Appeal allow the Secretary of State's appeal, but the Supreme Court restores the tribunal.
yes,
Despite Mr. Tamori's best efforts.
Yes. Yeah, so what we get from the tribunal's treatment, sorry, that with the Supreme Court's consideration of the tribunal's treatment of issue 3 is at paragraph 105. Now, it was said by the Secretary of State in that case that it was an error not to consider the rules discreetly. However, as the court points out, the terms of paragraph 3399A are in exactly the same terms as section 117C4. The same is true of section 117C6. We say that's important because this is a comment made by the Upper Tribunal when looking at the First Tier Tribunal's judgment, and I don't want to have to come back to SC Jamaica when I'm going through the judgment. I'm just drawing the court's attention to the way that the Supreme Court dealt with that criticism. But the key part of the case to which I have regard is that under the paragraphs dealing with the fourth issue, Now, in this case, unlike the instant case, it was said of the First Tier Tribunal judge that they had embarked on a freestanding assessment, that's to say outside the terms of section 117C. And what the court says at paragraph 111 about the correct approach, where the two exceptions do not apply, and the court will recall, I'll come to it shortly, but that the First Tier Tribunal found that the two exceptions did not apply. So I don't know if the court just wants to read through paragraph 111, but it's really helpful.
Right. Yes.
There are some other criticisms made about the terminology used by the judge. In that case, they don't arise here. But what we say is material is that it's quite clear that not meeting the terms of the exceptions doesn't mean that the proportionality assessment doesn't have to be considered under section 11766. It does have to be. So the starting position is that the public interest requires deportation. And then the task is to go through all those the elements relied on by the appellant to determine whether, in light of all those factors, that that public interest is outweighed. Owing to very compelling circumstances. Now, just referring back to section paragraph 83. In that case, we can look back at the way that the First Tier Tribunal judge in that case dealt with the seriousness and the public of the offending and the public interest requiring deportation. In paragraph 111, the court says that was expressly considered fine. If we go back to paragraph 83, we can see the court's summary of how she approached it.
Yeah, I was just reading this. The reference to the public interest is to be found just between F and G, yeah, within paragraph 83.
Yes.
I imagine the criticism was that, having dealt with it in that context, the First Tier Tribunal judge didn't say it all again when going into the alternative very compelling reasons analysis. Is that?
Yes.
Yeah.
But obviously that would be double counting.
And that was the criticism.
Yes, exactly. Which failed. Yeah. That was all the authorities I wanted to take the court to at this stage. If I could now turn to some parts of the material that were before the First Tier Tribunal judge.
Yes.
And we find that in this.
I think it's right, isn't it, that his citations from, for example, Miss Lackenby's report, it's not in dispute that that's what Miss Lackenby's evidence is fairly summarised. I'm not sure that Mr. Tabori takes much issue with paragraphs 1 to 22 of the FTT decision. He says that 23 and 24, which are the reasons for the decision, went due. But speaking for myself anyway, you don't have to spend much time in reminding us of the conclusions, for example, of Ms. Lacken, because I don't think they're in dispute.
It's not so much her conclusions per se that I was going to draw the court's attention to. But in support of my submission that the First Tier Tribunal was wholly entitled to reach the conclusion she did on the basis of the material before her, part of that harks back to what H.A. Iraq says, which is that in many cases, the First Tier Tribunal won't have a lot of reliable information about risk. And the kind of information that this First Tier Tribunal judge was wholly unusual in my submission. The quality and nature of the reports were almost unique in my experience of deportation appeals. And I just wanted to flag up a couple of matters. And this really relates to the weight that a First Tier Tribunal is entitled to place on a report of that calibre. So the first point to be made about the Lackenby reports, which begin at page 90 of the bundle, is that Ms. Lackenby was in a position to track through from 2013 till 2024, in fact.
Sorry, I think I'm in the wrong place. What page was
Sorry, it's 196. I've been, sorry, I'm looking at the various page numbers on the page.
Sorry, I thought you said 90.
I did, and I was wrong, and thank you for drawing my attention to that. It's 196 at the bottom of the
Yes,
page.
That's lovely. Thank you very much. Sorry.
Forgive me.
I'm there now.
So as I say, the first point I make is that unusually, highly unusually, Ms. Lackenby was in a position to track through the progress of this individual from 2013 all the way through to 2024, as it turned out. But for instant purposes, 2022. I'll take the court to the most recent, to the relevant report. So she had historic context, both how he was presenting and how she assessed him in 2013, and was able to determine and compare by the time she came to do her report in 2022. It's that report that I place particular reliance, obviously, because that was the most recent report, which was before the First Tier Tribunal. But the particular issues that I point out to the court, if you look at 1.2, the paragraph, the second paragraph on page 240, which is the page 3 of the 2022 report, you can see that Ms. Lackenby is a specialist psychologist member of the parole board and chairs hearings to determine whether individuals have committed serious offences and are imprisoned are suitable for parole. She trains newly appointed parole board members and mentors new members and members working towards accreditation as a chair. She also sets out details of her experience there. She summarises her findings at page 241. It starts at 240, but the key aspects are at 241. 2.3 at the bottom of his. I don't know if the court just wants to read through the information on page 241, but 2.3 to 2.7.
Yes. Yes.
So she identifies that that she assesses him as low risk at 2.4. She points out that there's no such thing as no risk and puts that in some context. And then the findings contrast dramatically with the assessment of the probation officers at the time of conviction. Going over the page, she also points out at 2.8 that if Mr. Majera were returned to Rwanda, there would be significant concerns that this would have a debilitating impact on his mental health. As a result of reduction in the quality of support he could engage in with his family, there is also a significant risk that symptoms of PTSD could re-emerge due to being returned to the source of his traumatic experiences.
The Upper Tribunal judge in the decision on the merits expressly referred to and accepted these aspects of this lack in this report.
Well, I have submissions to make about that in that judge's analysis if we get there. I mean, obviously when I get there, but
yes.
But in key terms, that was a matter that would have been in the mind of the First Tier Tribunal judge considering the Lackenby report. And as we know, the First Tier Tribunal judge carefully stated that she'd read the documents in the bundle that were provided to her. She should be taken to have taken all those matters into account unless shown otherwise. She gives quite a lot of detail of the method of her assessment. She refers back to the OASIS assessments at page 245. She points out the limitations of actuarial tools such as the OASIS, and then she points out at 883 that those actuarial scales are necessarily supplemented by the use of structured professional judgment. And she sets out the tool that she uses at 8.4. She sets out the historical risk factors in a lot of detail at 8.9. She distinguishes between what she describes as static or tombstone factors, unchangeable factors at 8.9. And she points out that in that forensic analysis and as part of her professional assessment, they should not outweigh the progress on other dynamic factors. Now that is expert evidence in my respectful submission. And then she brings the summary conclusions up to date, having reviewed the information from the probation service, and she indicates in her report that she spoke personally to the offender managers, so she had direct contact with them. and she sets out her conclusions at 252 onwards.
The FTT judge. I understand why you want to share to us in the original source. I'm a bit concerned about time. You've got
Yes.
a lot of ground to cover.
I accept that, but I don't want to have to come back to the content of the
No,
report
no,
when I get to
certainly.
round two. The point I'm making is this was an intensely high quality piece of forensic analysis that the First Tier Tribunal was patently permitted to give significant weight. There was no countervailing evidence. Indeed, what Miss Lackenby said doesn't appear to have been challenged at any stage. This is not a situation in HA Iraq where what can a First Tier Tribunal do? They just don't have enough forensically reliable information. This was a case, unusually, where that forensic information was available to her, provided by an expert who was manifestly well qualified to provide that information. And it's clear, as I attempted to highlight, that we weren't just talking about staying clear of offending. We were talking about what she described as an exceptional commitment to changing his life in very difficult circumstances, and for all the reasons set out by Ms. Lackenby, a concomitant reduction in risk. In addition to that, the risk of harm to him of being returned to a place which he had left as a child and in which he had suffered traumatic experiences which risked being re-traumatised if returned there. So I'd like to turn then, if I may, to the First Tier Tribunal's judgment.
Yes.
So we find that at page 78 of the full bundle. So it's my submission that this judgment, this decision, amply meets the requirements of Lord Justice Lindblom's practice guidance. We see the summary at paragraph 3. I hear what the court says about Mr. Tabori focusing his attack on those two paragraphs at the end, but for we are all aware of the principle that these judgments have to be read as a whole, and it would be wrong to take a couple of specific paragraphs, in particular where, as I'm going to attempt to show, the ground has been covered if one reads the judgment as a whole. Questions of whether the First Tier Tribunal could have expressed him or herself differently are not, in my respectful submission, matters which militate in favour of a finding of an error of law. So, first of all, at paragraph 5, the First Tier Tribunal judge says she's carefully read and considered all the documents relied on. We have to take her at her word. I'm assuming that Judge Young Harry is a
She
woman.
is.
I'm grateful to my colleague. Not having appealed in front of him myself. We can see that the witnesses were questioned and cross-examined, and additional witnesses were called. We see that at paragraph 6. Obviously, there's the degree of forbearance that an appeal court must show when seeking to interfere with the findings of court below, where the court has seen and heard the witness give evidence. Reference is made to the record of proceedings at paragraph 7, where it's clear that the judge had set out the evidence and arguments as she records. She correctly, paragraph 8 directs herself that this is a section 32 automatic deportation case, and the question is whether the section 33 exceptions apply. That would include article 8. She refers to the rules, and then she points out, I am to give consideration to the statutory framework. So she properly directed herself to the correct part of the law, and she sets out in detail section 117C. She properly directs herself at paragraph 10. I keep in mind the deportation of foreign criminals, that's to say foreign criminals within the meaning of the UK Borders Act, is in the public interest. The more serious the crime, the greater the public interest in deportation. She properly directs herself there. As to the purpose of crime prevention, but also the deterrent effect. And we refer back to the part of the sentence, part of the judgment in ECHR that my Lord, Your Justice Bean drew to my attention. Then on the findings and conclusions, having set out what she's taken into account, in summary, she then sets out, I must consider whether there are very compelling circumstances over and above the exceptions set out above, which outweigh the strong public interest in deportation. We know from SC Jamaica what that means. I must also consider whether any of the exceptions in section 117 apply, 4 or 5 apply. She finds that they don't apply. She properly directs herself. Given the requirements of section 11C4 are not disjunctive, I find the appellant cannot show he falls in within this exception, and then for completeness she makes findings on those individual aspects of 11C4 in any event. Technically, of course, that would be obiter if it's not a matter that she was required to make findings on, because she already found that he fell at the first hurdle. Then she goes on. The appellant's offence, I must decide whether there are compelling circumstances over and above the exceptions. The appellant's offence was particularly serious. So she's obviously got in mind the particular seriousness of the case. And this is reflected in the sentence he received. And then she notes the offence was committed 16 years ago and when he was released. The appellant claims he found himself in debt to unsavoury people. She sets out his explanation. But it's quite clear that she's taking as her starting point the seriousness of the offence. And then she's saying, well, this is very serious. The public interest is in deportation. What is there that weighs against that? He sets out the explanation there. She refers to the passage of time, reducing the weight of the public interest to some extent, and that's correct on the authorities. It's clear that that's a matter which in both Heshimali and Bultif and H.A. Iraq is listed in the factors that can be taken into account as material. She records what's said about his behaviour in detention. And about progress in detention. she properly directs herself to the Devasina at paragraph 14. I use the appellant's previous appeal determination while the appellant was still serving his sentence as my starting point. So she's properly directed herself that that was she was required to do. And then, treating that as the starting point, she goes on. She says that to record the key parts of the tribunal judgment and what their findings were. And then she sets out where the appellant's been tested at paragraph 15. She sets out having had the benefit of hearing from Ms. Lackenby at paragraph 16. She sets out the key parts of the evidence that she heard from Ms. Lackenby, bearing in mind that it's my submission that she was entitled to place a great deal of weight on this analysis because it was the best evidence that she had about risk and about matters material to the very compelling circumstances test. She sets out at paragraph 19 that the family support is relevant and necessary for his well-being and that of his family members. At the bottom of paragraph 19, she refers to she doesn't accept that's sufficient evidence of obstacles to integration because she's already made that finding, but she takes it into account, and it's right that factors which wouldn't necessarily succeed or be determinative on their own may nevertheless be material to the proportionality exercise. And then she sets out at paragraph 20 that she weighs the information that Ms. Lackenby gave that the appellant is now a low risk of offending against the pre-assessment in the OASIS report. So she's looked at it for herself. And she finds as a fact that the appellant has taken on board the suggestions in the OASIS report for reducing the risk factor. So this is more positive evidence of work to rehabilitation, which goes beyond the mere absence of reoffending. She takes on board Ms. Lackenby's view that face-to-face contact with the family is vital for maintaining his well-being at 21. She finds that the evidence that she has in front of her of him being tested in the community in difficult conditions is evidence that he is now making better decisions. And then she, at 23 and 24, this is not, it's wrong in my submission to take those paragraphs in isolation. They plainly follow on from the previous paragraphs. The various findings she has made and the various matters that she has had regard to in the paragraphs that I've taken the court to plainly inform the conclusion that she reaches at paragraph 23. She has taken the orthodox approach we submit of starting from the position that these are serious offences and the public interest, there's a strong public interest in deportation, and then gone through the evidence to determine whether that taken cumulatively is capable of outweighing that strong public interest. At paragraph 24, she properly, and applying the authorities that I've taken the court to, finds that the passage of time has reduced the public interest in deportation, and then concludes that as a consequence, in light of all those matters, very compelling circumstances test is met. clear in my respectful submission, going through the summary of the evidence that she heard and accepted, that the judge had done exactly what the court required in HA Iraq and SC Jamaica, which is that she looked beyond. Is it just a question of absence of reoffending here, or is there more? Is there more in excess of that? And if there is, what is it? What does it show? Does it show reduction in risk of offending? Does it show efforts to rehabilitate going beyond the mere absence of offending? If it does, what weight should I attach to that in the very compelling circumstances test, taken with the elapse of time and the other matters in respect of family relationship and the risk of re-traumatisation on return to Rwanda? That's, in my respectful submission, wholly orthodox. So could I then turn to how the Upper Tribunal dealt with that judgment?
Could be said, it will be said, that this judgment really says very little about the conviction. It says in paragraph 3, following a series of mainly driving related cases, was convicted of robbery. He was 23 years old. He received a discretionary life sentence, 7-year tariff, varied to IPD. That's pretty much it, isn't it?
Well, it's not, my lord, because she then goes on to say that she treats the first, following the Asylum principle, she treats the approach that the first tribunal took to the offending as her starting point. Mm-hmm. So that she's not doing this in a vacuum. She has to start with what they said, and she summarises briefly what they said. Succinctly, it's true, but it's plain that she had in mind that she would have to treat the offences in the same way that the previous tribunal did. She wasn't required.
So you don't think it was necessary, given the proportionality exercise that had to be undertaken, to be more detailed about the seriousness of these offences?
Possibly could have been different if the Devasselan test didn't apply. So she.
So you're saying that really you just read in what the first judgment.
Yes, because she obviously had regard to it, because she treated it as a starting position. She'd obviously read it because she summarised the key parts of that tribunal's view.
She does indeed, paragraph 14, but the tribunal found the offence should not be categorised as a minor offence, so that's a masterpiece of understatement. They had regard to the appellant's previous offending and observed the index offence was a clear escalation in his offending. Well, that's an understatement as well.
Well, it's a clear escalation. She's repeating what they found, which was that they found it was an escalation. She can't do anything different. That's what she says. But what she had done in this case, in my respectful submission, is what First Tier Tribunal judges are encouraged to do, which is to pitch the offending at a point which is reflects the seriousness of the offending, and that's what she does. And then to take the approach which I think my Lord Justice Warby was referring to, which is to, at that point, then weigh against that offending what is in. So it's reasonable that the emphasis of her, or the bulk of her determination would be going through those factors, because the starting position is that the law has set the public interest at a very high level. The law has set the public interest. This isn't a, for instance, this isn't a sort of a proportionality exercise where you'd be doing a balance sheet on one side a set of factors, one side another set of factors. It's completely different. This is a case where the law has set the seriousness of the offending at a certain level, such that only very compelling circumstances will be sufficient. So she starts taking that offence, that serious offence. She sets out the key parts of the offence, and then she asks herself, is there sufficient in the matters relied on and the evidence before me to outweigh that, to reach the very compelling circumstances? Yes, she could have said more, but it's quite clear she'd properly applied herself to the right tests and the right and the key aspects of the offending.
Okay, well, that's what we say about the FTT, and you were going
Yes.
to take us to the Upper Tribunal, the error of law decision, or the substantive.
Before I go to the Upper Tribunal, just a couple of references about what the Upper Tribunal's task is in a case of this kind. And we find that in the authorities bundle. If we look at the at tab 2 and 3, so tab 2 is section 11 of the Tribunal's Courts Enforcement Act. So we see at section 11.1 that the right of appeal is a right, and this would have been the Secretary of State's appeal, to the Upper Tribunal on any point of law arising. So it's appeal on a point of law. And the powers of the Upper Tribunal at section 12.1. I'm going to make brief reference to something that I think this video is going to, while I'm here, is going to deal with in more detail. But it's clear here that subsection 1 means that the tribunal can't set aside a First Tier Tribunal decision unless the decision concerned involved the making of an error on a point of law. And subsection 2 sets out a discretion that the court, statutory discretion that the court has to exercise on, if it finds one, what it should then do. That includes looking at where facts should be preserved. I'm not going to turn up your Phage and Warby and all those cases. We know that if the court, for the court's judgment, there's a recent summary in the Deutsche Bank case of all the principles, which is quite handy. And I'll just put a court's note.
So we don't just say Warby paragraph 2 anymore.
I think it's helpful sometimes to remember, you know, where all that comes from, but anyway, it's all summarised.
We do know it.
Yeah, of course.
We do.
Anyway,
the First Tier Tribunal is the fact-finding tribunal. It's not enough that the Upper Tribunal, or we for that matter, would have reached different conclusions. You have to show the FTT made an error of law. You
Yes.
view the decision as a whole. Island hopping is not recommended. Or
that saw and heard evidence. But I would just simply remark that obviously extends to matters of evaluation as well as findings of fact. does the court want me to take it to where I get that from?
All right, give us one reference to it.
We in Deutsche Bank.
Yes, I'm in Deutsche. Of course, I now can't find it.
Which bank is mainly about credibility,
Yes.
It's the contempt case, wasn't it?
I mean, I'm in there, but I just can't find a bit about the valuation.
Is it paragraph 50?
Paragraph 50.
Paragraph 50 and the quote from Waterloo.
Yes, well,
Yes. Oh, I'm so grateful to
No worries.
Mr. Tabori.
Yeah.
Yes, it's the quote from Waterloo at just paragraph 50.
and that in itself draws on some of Lord Justice Lewison's greatest hits.
I'm sure it does.
Yes.
So this applies not only to findings of primary fact, but also to the evaluation of those facts and to inference to be drawn from them, the reasons for the approaches set out there. And important to remember that appellate restraint includes not reading tribunal judgments or the lower court judgments with an unduly critical eye.
Yes.
In my respectful submission for the same reasons set out by the Supreme Court in ECHR, the AA disposal and SC Jamaica,
Yeah.
the tribunal judge could be taken to have been very well aware of the seriousness of the offence. At least because his lackey goes into the seriousness of a significant degree of detail. So then going to the other tribunal, up until paragraph 15, it's really a summary of the arguments for and against that were made to the court. I wasn't intending to take the court to those. Here at page 62. So I'm going to go straight, if I may, to the findings and reasons at page 65. The bundle, paragraph 16 onwards. So paragraph 17 there, it refers to the absence of a self-direction in respect of Iraq. That in itself, in my respectful submission, wouldn't be sufficient to support an error of law. What she then says, referring to paragraphs 23 and 24, in paragraph 18, she says the lack of any detailed assessment of or reasons for the ultimate conclusion that there are in this case very compelling circumstances. In my respectful submission, that's not a case, that's not a position which is supported by the detail of the First Tier Tribunal's judgment I've just taken the court to. She set out in some detail exactly what she thought was material to that test and whether it outweighed the starting position, which was the public interest in deportation. She says, the Upper Tribunal judge says, that requires an assessment of all the relevant circumstances, both for and against the appellant and the public interest. And although not compulsory, a balance sheet approach is recommended. With respect, the balance sheet approach, which I think Lord Thomas mooted in Hesham Ali, is a test which is useful in the if a proportionality test were at large, but in a case where section 117C 6 applies, the public interest is set already high, the public interest in deportation, and it's the question is, can that be overcome by the very compelling circumstances test? By contrast with the normal proportionality exercise at large, where you have a number of factors for and against. To take the approach, the balance sheet approach in a case like this would be to double count, because the threshold for being able to overcome the public interest is set in statute. And that's a factor which is recognised by the SC in the SC Jamaica case and the other cases to which I've taken.
I don't follow why, in a case of this kind, the balance sheet approach is not appropriate. Shouldn't a decision on very compelling circumstances go something like this? There's a strong public interest in deportation. Lord Hamlin says, and it's obvious, the seriousness of the offence is relevant, so that the more serious the offence, the greater the public interest in deportation. Here was why this offence was a very serious one. On the other hand, the factors in the appellant's favour are these. And the question is whether they constitute very compelling circumstances such as to outweigh what I've set out on the left-hand side of the ledger.
The point about the very compelling circumstances test is that it constrains the decision maker to treat offences that attract sentences over 4 years as being so serious such that only the very compelling circumstances test, succeeding on the very compelling circumstances test, will be enough. By contrast, in a normal case where you'd be looking at using the balance sheet, the issues would be at large. So you have a list of factors on one side, and a list of countervailing factors, and then you can look at them at large, as it were. The problem about taking a pure balance sheet approach in this case is that the statute already places. So if I can put it to explain it visually, the public interest is already heavy, and it's sufficient to outweigh that, rather than starting here and having a list of each side. It's the statute has placed that weight as already being heavy in the scales. The scales are not even.
It hasn't attributed equal weight to all offences that fall within each category. It doesn't say that whatever the offence in a serious category, the weight of the public interest is the same. It says the opposite.
That is correct. So the question is, from taking the starting position, was this individual judge mindful of the particular facts and the seriousness of the case, yes, she set it out succinctly, but that was her starting position. So, paragraph 19, having looked
And you would say that the Upper Tribunal judge is wrong at 19, would you? Because we have to read in the first of the First Tier Tribunal decisions,
yes.
even though they're not dealt with either in a balance sheet or any other way in the FTT judgment.
Well, yes, we have to assume, because the judge said she did, we have to assume that she properly treated those findings as the starting point, and we have to assume that she was fully mindful of the seriousness of the offence. She had a great deal of evidence about the details of the offence.
Do they not have to be brought back in again and dealt with specifically once she embarks upon the proportionality exercise?
No, because she starts with that. That's her position. The starting position is this.
Sorry, I'm not
Sorry.
very clear. I mean, of course, I understand what you're saying about the starting position. What I'm saying is that then when you get to the conclusions,
Yes.
and you're saying, I'm now looking at the compelling circumstances, there's the rehabilitation and all those issues that you've helpfully taken us to. But at that stage, should she not then have rehearsed in some detail in order to establish the particular seriousness of these particular crimes by this particular man before reaching the conclusion she did? Because that would appear to be the criticism at 19.
My submission, it's perfectly acceptable for a first-tier tribunal judge to start with the circumstances of the offence, and then say, taking that as the starting position, is there enough to outweigh that? That's my starting position. I now turn to the other factors. Can they cumulatively outweigh that seriousness, that public interest? That's an orthodox approach in my respectful submission. As I say, this first-tier tribunal judge could have expressed herself more fully, gone on in more detail. All that could have been done, but in my respectful submission, that doesn't. That's not a matter that can generate a justification for interference with her conclusions.
Well, that covers Upper Tribunal paragraphs 18, 19, 20. Fair to say that she makes the same point again and again, but then at 21 she goes on to other points not to do with the seriousness of the offence. What do you say about 21, for example?
The approach that's taken at 21 would appear to be at odds with paragraph 111 of SC Jamaica that I took the court to. again, when looking at the whether or not the exceptions in subsection 4 and 5 were made out, that's what that's a reference to. The fact that they don't apply doesn't mean that they don't proceed to the very compelling circumstances test. It's clear that that's compulsory. Section paragraph 5 of ECHR Act, paragraph 111 of SC Jamaica.
Well, of course. I mean, it's well established now that even if you are single and even if you are not integrated in the UK and lived here lawfully, so on, even if neither exception 1 nor exception 2 applies, you can still
exactly
qualify, but the upper tribunal judge is saying you would expect the FTT at least to mention it. If it's a point in an appellant's favour, for example, that he has children and or a partner who'd be greatly traumatised by his being deported to the other country, isn't it a factor to at least to mention that that doesn't apply and exception 1 doesn't apply either? So it really has to be something pretty unusual and exceptional.
well, the exceptionality and the unusual nature of the evidence is repeated throughout the judgment. The exceptionality of the rehabilitation, the unusual nature of the rehabilitation is throughout. But I would say this, again, the First Tier Tribunal judge has taken an orthodox approach. You don't get the benefit of this and you don't get the benefit of this. I'm going to go on to look at the other things, but you don't get those. They don't factor against, they don't weigh on the public interest side. The public interest side has been determined. What she says is, you don't come within those exceptions. I'm not giving you the benefit, the credit of any of those factors. I'm just going to go on to the subsection 6 very compelling circumstances test and look at what do you pray in aid of your position that test is met. That is a wholly rational approach to take.
Do we find out from the FTT just why those circumstances are so very compelling as to outweigh the significant public interest in deportation? We see what she says, he or she, I'm still not sure, about the compelling circumstances.
Yes.
And that she concludes that they do outweigh. But do we find out why?
We get the why from reading the whole of the judgment. The judgment, cumulatively, she says, I go on to look at what all the circumstances are, and I list them, I go through them, and taking all those matters cumulatively in the paragraphs that I've sent, I've taken the court to, succinctly agreed. But what she says, her conclusion follows on from the factors that she has identified. And that, again, is wholly rational and a sufficient explanation. Anybody reading this, getting to the end of the judgment, would understand that this judge decided that these circumstances were exceptional, that the evidence that she had in front of her, which she accepted, was sufficient for her to take that view.
Yeah.
And again, she expressed herself moderately. She didn't say this is a slam dunk win. She says it just tips the balance in his favour.
Now, speaking entirely for myself, I think you've covered the ground on round 1, little 1 and little 2. But have a look and see whether you have. And if you have, you might then want to go on briefly to ground 2, which I think logically comes next, and then leave a bit of time for Ms. Dirier to deal with ground 1, little 3.
If it's if the court would not object,
Yeah.
the way we'd structured our submissions is that
Ms. Dirier goes next. All right. Well, are we ready to move to that?
I just
think
wanted to check
Yes.
that I dealt with everything in the because obviously quite a lot of my argument is set out in the skeleton argument.
Yes. Indeed.
At paragraph 22 on the question of rehabilitation, in my respectful submission, the Upper Tribunal gets it quite wrong. What she says is that rehabilitation is a matter on which the tribunal must determine the weight to be attached to evidence, particularly as it's not normally a matter to be given any great weight. But that's not what the law says. The law's what is not a matter to be given any great weight is the absence of offending. She goes on at paragraph 22 to say there was nor is there a clear explanation of positive rehabilitation since release from prison beyond a lack of further offending. Well, that's just not correct. The judge set out what those factors were, and indeed I've taken you to the Lackenby report, which makes that clear. And then the judge says the reference to conduct and courses in prison were matters which largely predated the previous appeal and were not found to be sufficient at that time to outweigh the public interest. But that doesn't mean they're irrelevant now. They were determinative at that point, but they're still material. And then there's a general point made at paragraph 23 about the adequacy of the reasons, and in my respectful submission that is not a criticism that can be substantiated having gone to the evidence before the judge and the judgment itself. Again, she says it cannot be seen from the decision there's been a lawful balancing of all the relevant factors, nor can the final conclusion be understood by the losing party. In my respectful submission, for the reasons I've explained by reference to the judgment, again, that is not a fair or accurate description of the judgment of the First Tier Tribunal. It's not a criticism that can be substantiated having regard to the evidence. You'll note there at the end of paragraph 23 that the court then says, for these reasons, it's necessary to set aside the decision of the First Tier Tribunal and for the appeal to be heard de novo. I'm going to leave Ms. Dirier to deal with why that's wrong,
Yes.
if I may.
Yes. Right. Yes, Ms. Dirier.
Good morning. This ground, 1.3, put quite simply, challenges the steps or the lack of steps that was taken by Upper Tribunal Judge Jackson once an error of law had been found. And our principal submission is that once that error of law had been found, it was incumbent upon the tribunal to go on and ask itself a number of questions. And that was necessary in the exercise of its statutory discretion as mandated by Section 12 of the 2007 Act. And that is to consider a number of things. And the first was to consider what the nature of the error of law was and whether there were any findings of fact which could have been preserved and to what extent. And asking those questions would have informed whether the matter was to be remitted back to the FTT or whether it was to be retained and reheard in the Upper Tribunal. It will be seen when we look at the decision, and I'll take you to it shortly, of Upper Tribunal Judge Jackson that she doesn't consider any of those questions, and there's no reference that's made to the practice statement. It might not be necessary to actually refer to the practice statement, but at least there should be a consideration of some of those questions, and that is absent from the decision. And what we will see is that Upper Tribunal Judge Jackson goes straight to setting aside the decision in its entirety, not preserving any findings and providing no reasons for that course of action. And essentially we say that that approach amounts to a material error of law when you consider the established case law as well as the well-established practice statement. It might be helpful to turn to the practice statement. I appreciate that this court is probably very familiar with it, but it might be helpful just to turn to it. This is in the authorities bundle at tab 5,
Yes.
and it's at page 26.
You're educating me, if not, their lords.
No, I don't know it as well as I should. So
Right.
paragraph 7.2.
So 7.1 just sets out what section 12.1 of the 2007 Act sets out, and that's the power to remit or to retain and rehear. And paragraph 7.2, if my lords, my lady, you could read 7.2, that would be nice.
Yes, and 7.3 as well.
And 7.3, and the most important part of 7.2 is the recognition of the fact that the usual course is that the upper tribunal will, if it can, retain the case in order to remake it, unless there are two specific exceptions, and it requires the upper tribunal to consider each of those exceptions. So this is clear guidance as to how the statutory discretion should be exercised by the upper tribunal. And that discretion, or rather that practice statement, has been considered by this court actually in the case of AEB. I'll ask the court to turn to that next. This is at tab 28 of your authorities bundle. So tab 28 at page 543. And we're looking at paragraph 15. That's page 543 at paragraph 15. And we're starting 4 lines in. Where it begins, the terms of paragraph 7.2 do not seek to lay down immutable rules, still less do they seek to establish propositions of law or to fetter the broad discretion afforded to the upper tribunal by section 12, but they do seek to reflect what is likely to happen in some circumstances and not in others. And as the SPT observed in J.A. Garner, this is the important part, the general obligation upon a judge exercising a discretion to give adequate reasons for the course they decide to adopt is all the more important when they're proposing to adopt a course that departs from the normal approach. And the reason why I highlight that is because Upper Tribunal Judge Jackson departed from the normal course. When you look at the nature of the error of law that she found, and also by retaining it and not preserving any findings of fact. Just for your note, and I'm conscious of time, similar has been said by the courts in the cases of TA and AB. So for your note, that's it. So TA Sri Lanka is at tab 22, and it's page 435, paragraph 7. And AB, which is in the Upper Tribunal, that's at tab 36. And it's page 758 at paragraph 41. So that essentially gives us a flavour of how this should be interpreted.
Sorry, I'm being a bit dense. In what way was Upper Tribunal Judge Jackson departing from the normal course?
So what we'll come to when we have a look at her decision is that she had ordered a de novo hearing, so setting aside all of the findings of fact as they existed. So that required extensive fact finding to be done. And when you look at 7.2b, that is a consideration that the tribunal needs to consider when thinking about whether to retain it or to remit it back to the upper tribunal. And that's in pursuance of the overriding objective.
So it's departing from the exception. That's the focus of your argument.
That's right.
We've got two norms then. The normal thing is to remake it.
To remake it,
Then there are two exceptions which have got to be addressed and reasoned out.
that's right.
The norm, if one of those applies, send it back. Or preserve them.
And the question is, for the tribunal, the first question, which the upper tribunal does not do, is to first establish what the nature of the error of law is in order to ask itself those questions. My lady.
Just picking up what Justice Warby said. Is it really that the normal becomes if A or B are satisfied, then it goes back such that it's an error of law if it doesn't, given what it says at 7.3?
So the purpose of 7.3 is just to, it might be helpful actually to turn to AEB, which sets all of this out in quite some detail.
Sorry,
you were trying to be compact and concise. And
We've still,
we've
we've
we
got
can
us
go
to
through
it,
it.
and then
Sorry.
yes. So are we back to page
Tab
tab
36.
28, 543?
That's right. Yeah.
Is it AB or AEB?
AEB.
AEB, yes.
I think there's a number of other cases that are AB in the bundle.
Yes,
So this is it.
I've railed against the use of AB and XYZ in
They say
case
children's cases are bad.
Yes.
Right. So AEB, it begins at page 539.
Paragraph.
Just going to find the paragraph.
It was 15 last time. Are you still at 15?
Last one. So if we look at paragraph 9, this is at page 542. I'm just setting out what paragraph 73 is. Or it might be helpful actually to read paragraph 8 and 9 together. My apologies.
Yes. Isn't there a distinction between AEB case and the present case? In the AEB case, the appellant was saying, I didn't have a fair hearing before the First Tier Tribunal. I wanted to call some evidence, I was refused an adjournment, that's unfair. And this court agreed that it was unfair, but you're entitled to one fair hearing before the FTT. But here it's not suggested that the FTT hearing was unfair, and it's the Home Secretary who's complaining of an error of law.
That's right. It might be helpful actually to turn to Upper Tribunal Judge Jackson's decision to look at actually what she says.
Yes.
The argument that I'll be making is actually it's not entirely so. Whilst the language of procedural unfairness isn't used, the effect of the findings that Upper Tribunal Judge Jackson makes when you look at paragraph 23 in particular, effectively the judge is saying that the First Tier Tribunal has materially erred in being able to answer the key question in the appeal. So the exercise of the question of very compelling circumstances. So according to Upper Tribunal Judge Jackson, there's a wholesale failure to properly apply, to name the test or apply the case law, and then to go on and consider all of the relevant considerations. So that's a failure in properly considering the case. So I would argue, when we look at paragraph 23, which is at page 66 of your supplementary bundle, sorry, of your core bundle, that it could be said that that amounted to an error of law, to a procedural error, irregularity.
There's got to be an error of law, or we wouldn't be having the discussion. But,
Of course.
But you say that
It went to the heart of the appeal, my lord, and so and what the tribunal had to consider in those circumstances, as 7.2 A and B considers, or rather 7.2 A considers, is the loss of that two-tier decision making, so that staged approach. Paragraph 23 is the only reference to why the tribunal says she's ordering a de novo hearing. This is despite the fact that there were no challenge to any of the findings. Much of the beginning of grounds 1 and 2 focused on how the expert Lackenby and also the oral evidence was not challenged. And at paragraph 23, you can see that the judge says, for those reasons, it's necessary to set aside the decision of the appeal to be heard de novo on the basis that the losing party was not able to understand the reasons for that. And so we say, when you consider that question, if we look at how that should be applied to 7.2A, the question that the upper tribunal should have asked itself is whether the error of law was of such a nature that the appellant was deprived not only of a fair hearing, and or an opportunity to put his case properly and have it considered before the FTT. And that's with the full gamut of understanding all the requirements and considerations under the very compelling circumstances test. The other part of that consideration is the impact of the loss of the two-tiered decision making, and also the impact that would have on the requirement to meet the very high threshold of the second appeals test. And the error that we say is the failure to ask any of those questions. It was incumbent upon this judge to ask herself, when she was ordering a de novo hearing in the circumstance of not preserving any findings of fact, to ask herself those questions. That in and of itself is, we say, a material error of law, and she should have turned her mind to it. And if she had turned her mind to it, she may well have canvassed with the parties, as is usual, what the appropriate course would have been had an error of law been found. And it appears from the decision, because there's no reference to it whatsoever, that course wasn't taken. I note that this was a decision that was made having been reserved, and so paragraph 23, like I said, is the only place really where there is that consideration. And if you look at page 66, notice of decision simply says, I set aside. And in fact, this is relevant to 7.2b, when there is a consideration of the nature and the extent of fact finding in line with the overriding objective. She recognises that that's extensive fact finding, because she lists it at 1 for a 1 day, for 4 witnesses to attend to give oral evidence, and for further evidence to be uploaded. And so that is significant, the level of fact finding that had to be done. Essentially, the appellant was being required to put his case again from scratch, but again, without the benefit of that two-tier decision making. Taking a step back of the questions that the tribunal should have asked itself when it comes to 7.2b, is firstly whether there should have been any findings of fact that were preserved. That question isn't asked. And that's material because there was no challenge to any of the findings of fact. We may well have been in a different position, or rather my argument would have been different potentially, if the judge found that that there were findings which could have been preserved, and it required just an exercise of considering what the impact of the law was, applying it to those facts, then that could have been retained in the upper tribunal. What AEB, or rather Begum, which I'll take you to, the head note of Begum is helpful. The difference in Begum, so it was an AEB style error, but in Begum it was a very narrow issue. It didn't go to the heart of the appeal like it did in AEB, and like I say, it goes to the heart of the appeal in this case. And so had the judge been cognizant of what that guidance was and the overriding objective, it may well have been that she would have remitted it back to the FTT. But the key really is that reasons need to be provided, and this is simply absent, it's devoid of any reasons, and that is the error. So if the judge was able to justify it and say, I've considered this, there's not much further evidence to be gathered, etc., then it may well be that it could have been retained in the upper tribunal. But the failure to even ask those questions, we say, amounts to material error of law.
So does it come to this, Mysteria, that it doesn't appear that the judge did canvass with Mr. Furler and Ms. Nolan, who were the advocates. If I do allow the appeal, should the further hearing be here or
In the FTT.
limited to the FTT? And if here, should any findings be preserved? She didn't do that, and you say if she didn't do that, then by the terms of paragraph 7.2 of the practice direction as interpreted in A and B, she should at least have said, I am satisfied that there would be no unfairness to the appellant in retaining the case in the upper tribunal and thus depriving him of the two-tier system. And there is no extensive finding of fact which requires the remittal to the FTT. And you say her failure to do either of these things constitutes an error.
That's exactly right. And really at the heart of it is that, and I'm conscious of the time, the final point to be made is that there was no basis that was provided for setting aside any of the reasons in which she did. And that failure amounts to a material error of law. In the circumstances that the evidence was not challenged by any party, it wasn't a challenge on the findings that were made. And the case law makes entirely clear that in those circumstances, that reasons really should have been given. And so there's different parts of the argument, which is you should have asked the questions, you didn't. But even if you didn't, did you, with regards to the facts, thank you, if you didn't ask yourself those questions, in any event, what is the reason that was provided? And frankly, there is no reason in the determination of Upper Tribunal Judge Jackson. I'm conscious of time, unless I can assist you any further. Are there any questions?
Thank you very much, Ms. Thierry. That leaves you 10 minutes for ground two, Ms. Weston, which seems to me about right.
Well, I'm going to do my valiant best. Thank you. So the argument is made in the skeleton argument in some detail. I'm not going to repeat it. I won't be placing any reliance on the deterrence, the approach taken to deterrence and the evidence of deterrence. However, we do say that there were two very significant errors in the judgment of the Upper Tribunal. Which we can, without going through the whole judgment is a much lengthier judgment, obviously, than the one we were dealing with earlier.
Yes.
But the key parts of the analysis are quite short. Having made various findings, there's no challenge to Miss Attenby's evidence. He seems to accept it. However, there are two aspects in respect of which the judge erred in his assessment of whether the very compelling circumstances test was met. The first of those we see when we turn to paragraph 64. I think we can reliably start at the end of the judgment, because most of it is taken up with findings that I don't take on the issue.
Yes.
But so if we look at paragraph 57, we can see that the 4 factors that were set out by Mr. Ferner in the hearing before him, which was sufficient to establish the very compelling circumstances. The first of those relates to the reduction in the risk of reoffending. The second relates to delay. And we say that the judge erred in his treatment of the issue of delay and the relevance it had to the test to be applied. And we find his discussion at paragraph 58, it's worth just reading through that to see what the submissions were. And then, I don't know if the court got to the end of paragraph 58, thank you. So we see at paragraph 64 the judge's reasoning on delay. So in that paragraph 64, the judge considers that the appellant has been the subject of a deportation order since November 2012, and he was well aware that that appeal against the respondent's decision to refuse his human rights claim had been dismissed. He'd only just exhausted his rights of appeal, says, and then reiterates what happened in September 2015. And then he says there was a delay until May 2021, when the appellant's representatives were invited to provide up-to-date information. Then there's the response received relatively promptly in July. Then it says this: I accept, as Mr. Bates admits, that during this time the appellant was aware there was an extant deportation order, and the appellant could have no legitimate expectation that the application would succeed. And that paragraph 65, I accept there has been looks like a typo delay, but that delay has been to the appellant's advantage because it's given him at least some opportunity to demonstrate his ability. I give due weight to the delay in favour of the appellant. During that period of delay, the appellant, I accept, has demonstrated he has the ability to abstain from offending, and I give him credit for that. But the key point about the authorities on delay is that delay, particularly by the state, has an impact on the weight to be attached to the public interest. There are a couple of authorities which make that clear.
Doesn't it depend on who's to blame?
Sorry?
Doesn't it depend partly on who's to blame?
Well, yes, I think it's fair to say that we're not talking about the period of delay while he was in prison, serving his
No, of
sentence.
course not.
But we are talking about. I'm thinking in particular of MNT, which is in the Bundle Act tab. Yes, that's right.
MNT, tab 19.
Yes. So it's paragraph 54. And that's referring back to the observations of.
You helpfully set this out in your skeleton at 56.
Yes, I set
Yes.
it out there. But it's clear that this wasn't a legitimate expectation case. This wasn't about that's referred to by when the judge refers to legitimate expectation. This is a question about it's now 16, 17, maybe 20 years since the offending behaviour. It's maybe 20 years since offending behaviour. The delay in this case means that there has been passage of time since the offending, and the authorities, and I think E.B. Cosper is the key authority, Lord Bingham, at paragraphs 14 to 16 of that judgment. It's in the bundle at.
Yes, well, again, in your skeleton at paragraph
Yes.
54.
So we say that the judge treated it as being the delay was an opportunity to prove rehabilitation or to show rehabilitation, to demonstrate rehabilitation. But in fact, the authorities make it clear that delay also has another function, has another role to play in the test, and that is that the longer it is between the offending and the deportation decision, the decision under question, the less the public interest in deportation. And in this case, there was significant delay by the state. The other point I wanted to make relates to the approach that the judge took to the impact on the appellant's mental health, which was provided by Ms. Lackenby. So we say we say that there was clear evidence that he was at risk of a deterioration in his mental health and at risk of being traumatised. And the way that he deals with this evidence from Ms. Lackenby is to say that paragraph 54 of the judgment I think the court just wants to read through paragraph 54.
Yes, will do.
So we would say that where the judge says, "I've borne in mind the report of Ms. Lackenby and her opinion that return to Rwanda would have a debilitating impact on the appellant's mental health as a result of the reduction in the quality of the support he engaged in with his family," he omits the important aspect of the evidence to which I took the court, which was the evidence relating to him being re-traumatised by being returned to a place where his experiences as a child were traumatic, including the murder of his father.
He deals with that further down that paragraph. I may say very briefly, but it's
What he does, in my respectful submission, is that having heard the appellant give evidence, bottom of paragraph 54, he says there's nothing that will prevent him from engaging fully in life in Rwanda, and he states that he's good at managing his mental health. So over the page of paragraph 54, he refers to a period of adjustment. He's acquired skills he'll be able to continue to develop in Rwanda. It just does not deal with whether he would be able to manage quite so well if he was being re-traumatised by being put back in the situation in which he was as a child. There's just no treatment of that at all. And there is that finding that he'll just be able to cope with without, it's speculative, wholly speculative, it's without substance. It ignores the very clear indication in the unchallenged evidence of Miss Lackenby that there are very clear risks about returning a person to a place in which they've experienced such trauma. He might be able to manage his mental health here. How will he be able to manage it if he is re-traumatised, as Miss Lackenby indicates he may well be? That was an essential factor to be taken into account on the unchallenged evidence, and there's no substance, there's no underpinnings, there's no evidential underpinnings of the findings that he'd be able to cope in such circumstances, or that he wouldn't be adversely affected by that. The focus is on being separated from his family, doesn't really do that at all. So that's what we say about the judgment. Unless on the time, unless I can assist further, those are my. Can I just consult with my colleague?
Of course, please do.
Yes. Ms. Guerrier has pointed out something important, which is that there's a finding at the bottom of, we do make reference to this in the skeleton, but just for completeness, if the court will permit me, the bottom of line of paragraph 67, where he begins standing back.
This is Mandalia.
Yes, it is,
Yeah.
my lord. I don't know if the court wants to just, that's a short paragraph, paragraph 67.
Yes.
So he says, I would not go so far as to say that on the evidence before me, I can make a finding that the appellant is unlikely to reoffend. Well, that's exactly what Ms. Lackenby said. And if he disagreed with it, he had to give reasons why.
I think he's giving the reason that the circumstances in which Miss Lackenby has reached that conclusion are that the appellant has been under threat of deportation throughout. That may not be a good reason, but it's a reason.
Well, it's something my lord has read into it. He doesn't. If he's what I mean is.
I'm actually not reading it in.
No.
What it says.
What
He's demonstrated he can abstain from offending. However,
Yes.
he's been under the threat of deportation, and I would not go so far. That seems to be a logical sequence of reasoning.
Yes.
Criticised, but I don't think it lacks a reason.
What was necessary was a reason for disagreeing with looking at Ms Lackenby's reasons for reaching the conclusion she did, engaging with them, and deciding why he was going to disagree with the expert evidence. We just don't see any of that there. Again, you know, we can read in a bit more reasoning than there is, but that's precisely what the
All right. Well,
what the court was dissuading me from pursuing as an argument in respect to the previous First Tier Tribunal.
We'll break off there and come back at 2:05. Not encouraging it, but if after you consult Miss Derriere you feel you have a 2-minute point that you had forgotten about this morning, then we won't stop you making it, but then the baton will pass to Mr. Warby. 2:05.
All rise in favour.